Hi, everybody. Thanks so much for joining us today. I'm Liza Hausman. I'm the Vice President of Industry Marketing here at House, and we are so lucky to have with us today David Adler of the Adler Law Group. He's a lawyer, a law professor, an entrepreneur, a nationally recognized speaker, and his practice focuses on the needs of interior designers specifically. So that's why we're super excited to have him join us today. He's a 7-time Illinois super lawyer. I think it'll be fun to find out what that means. A former professor at DePaul College of Law, member of the Illinois State Bar Association, the Intellectual Property Law Committee, and the ISBA Privacy and Data Security Section Council, which is probably more info than you probably get into in this session today, where we're focusing more specifically on the 5 things every design contract needs. I know that we see in discussions on House and in other forums that this is a hot topic for designers on an ongoing basis, and they're always changing needs. So David, let's kick it off, and why don't you share with us kind of your overall thoughts and why this topic continues to be so important.
Yeah, well, thank you, Liza, and thanks for giving me this opportunity to share. As it should be clear from sort of my background, obviously I have a passion for this subject. I enjoy sharing my knowledge and, helping other entrepreneurs succeed. So I'm happy to, help your audience, have better contracts, right? Do better in business. And I'll give you a little bit of context to my background. I came into interior design as general counsel for a glossy publication, just a trade magazine. And because of that relationship, I wound up just getting a lot deeper into the industry, meeting designers, and sort of discovering that designers often had a lot of problems with their contracts. I would get a lot of questions. I would meet people at events and they'd say, I've got a client who's doing this, or, I have this contract, but it doesn't say anything about that. Or, what do you think about this? So that has sort of led to, what we're going to talk about today, which are, a summary of some of the key issues that I see in interior design contracts. And my clients come to me sort of one of 3 ways. One is that they might be looking to do their first contract. They're ready, they're ready to start a business. They understand that they need, terms and conditions to govern that relationship, but they've never done it before. Some of my clients come to me because they've got a contract, they've used it for years. Maybe, it was given to them from the last firm they worked for. Maybe they bought one of the very comprehensive forms that are available for some of the trade associations. But, they may have something in hand already and they just need to tighten it up, maybe make it more applicable to their particular business, and those sorts of things. And then sort of the third avenue that, contract issues come to me are, client disputes, or basically, when my designer clients are having an issue either with a particular client, with a particular project, with a particular vendor. So when you have those conflicts in the interior design business, the first place you start is, what's the contract say, right? So kind of taking all of those different contexts, I've distilled down kind of where I see the biggest, issues, the needs for improvement in contracts. And, we called it the 5 things every design contract needs. It may be, not every contract necessarily needs to have 5 things changed about it, right? But these are kind of, I think, some real high points that every designer should really kind of understand and, look for in their own contracts.
And David, you mentioned disputes as that third area, and I think the goal here, right, is to put a contract together to try to avoid those wherever possible. Is that a correct statement?
Yeah, absolutely. That's part of my my role as a business lawyer is I'm really looking to make deals happen, make sales happen. I am not looking to break things up or cause conflict. So, with that in mind, I kind of guide my clients to having contracts that are sort of fair and balanced, right? They're going to protect both sides of the relationship. They're going to be clear and unambiguous and make sure that they protect the designer so the designer gets paid when the designer should be paid, right? But also, not be unfair or penalize the client in sneaky ways or things like that, or create a situation where, there's going to be some kind of conflict down the road. So, I mean, that's obviously not the point of why you have these things.
Perfect.
So to kind of give everybody just an idea of what I see as the big, top 5 things that every design contract needs, here's a list, right? So the first one is establishing scope. And I'll break down what each one of these is in more detail and try and talk a little bit about more specific clauses that you might see. So establishing scope, this is really, the scope of services, the scope of work. I think designers have a pretty good idea in their head of what they're doing. The issue that I see most often is that what the designer thinks they're doing and what the homeowner thinks they're getting can often be 2 very different things. The second major topic is getting paid, right? Just understanding what is your business model, what is your revenue model, and then communicating that to the client so the client understands what they're paying and when they're paying. The third really big area is purchasing. My clients are always asking me about purchasing. So we'll talk about sort of the different approaches that designers take in purchasing and, what the different approaches mean to their bottom line. The fourth area, termination rights. So, your right to terminate a contract, to stop working with a client. We'll go into detail on that. And then lastly is not really, a contract section so much as, a contracting mentality, mind the details. And I'll talk a little bit about where, the details can trip up a designer or, cause problems down the road. So I also wanted to just kind of share some thoughts about, the contracting process. One of the things that I think people are often surprised to hear is that, contracts are enforceable whether they're oral or written. You can have an enforceable contract. And really what the idea is that, the 2 parties have sort of negotiated some exchange. There's a bargain. Each side is exchanging value. And the parties understand that they're undertaking legal obligations and that these legal obligations can be enforced in court. The reason we have contracts is that because it's so easy to form a contract, it's also very easy to sort of lose many of the details. And so the idea is really that, the contract needs to say everything that is going to be in that relationship. So that's why you want something that's, a little bit more thorough, a little bit more thought out, a little bit more formal, right?
And you mentioned that, contracts can be oral, but we're really advocating here is to have a written contract. I know that comes up still sometimes. Do I really need a contract? Is it important to have a contract? And it sounds like yes. The answer is yes. You would ideally have a written contract.
Yeah, absolutely. You want to have a written contract because if you don't, then you're subject to the he said, she said defense, right? Each person's going to have their own side of the story. And that's not to say that one person's side is necessarily wrong. It's just that there's 2 sides, right? When you have a contract, you avoid any ambiguity about what things mean. And that's really the focus of what we're going to talk about today. So let's talk first about what it means to establish scope. I've seen a wide range of ways to address this in contracts. Some clients prefer sort of a free and easy breezy approach to things like, well, I'll come up with a design concept and I will do some various other things that are sort of vague and open-ended. What I really advocate for is to think about some sort of a task list. And let's look at a couple of these specific. I don't want to get I don't want to steal my thunder there. Things like establishing specific tasks, specific duties, specific deadlines, right? It might be something as simple as, second bedroom furniture, right? But when you have specific deliverables, it's a lot easier for the parties to kind of objectively understand, what each side is getting out of it, right? So the scope should really be specific tasks. And one of the things that I see often are, either ambiguities or overlapping kind of tasks maybe, but just sort of the same language repeated throughout a contract so that it's not clear if it means different things at different points, which sort of leads me to, where or what are the kind of the legal reasons behind some of these problems. And that's when we kind of look at where what it is in the contract that's causing these problems, right? It's not so much that the parties can't agree on what they want. It's just that they have different ways of writing them. And so what I see are things like, compound clauses. And I know that you had asked me prior to our discussion today if I could maybe give you an example. And I had to go down to the archives, right? I had to kind of dig up kind of a crappy old contract that I hadn't seen in a while, so I could give you an idea of what's a compound clause that's going to cause a problem. And here's one that's pretty common. It has to do with the rights, not so much the rights, but your obligations if once you place an order for something, right? Can it be canceled? Can it be returned? Do you have to give the money back? So this says, when purchasing products, once an item has been signed off on, poor grammar, ordered and received, okay, so now there's 3 conditions, it may, again conditional, be non-refundable or valid for exchange only. Oh, okay, depending on the supplier's return policies, unless, another condition, the product is damaged, period. Okay.
Got it. Yeah.
And then
so you've got a lot of things. You got a lot of different things going on, and they're all smushed together where it's not clear what the role any one of them plays in a scenario.
Exactly. And so the problem you have is something comes up and you say, okay, well, let's look at what the contract says. Well, the contract's clear as mud, right? The contract doesn't say, yes, you can do this. The contract says, no, you can't do that. Contract doesn't address what the client's doing, right? So that's the biggest thing I see is sort of these things that are crammed together, a lot of conditional language. Contract drafting should be simple, right? So it should be pretty clear to people what's going on. And that's kind of the biggest thing I think I find. Ways to avoid this, or I guess reasons it crops up, are either, are primarily, I guess, the Franken contract, right? So the Franken contract that is either something you cobbled together from the internet, something you cobbled together from friends in the industry, right? Or something that started out as pretty good, but you wanted to add this clause here and you wanted to add that point there, and this client did this, so you want to make sure you never got a text message at 5 p.m. on a Tuesday, right? So let's put that in the contract, right? And it's just like, it is too much, right? And so you can't, by the time you start doing all these things, you wind up creating clauses that actually contradict each other in some respects. So my job is always to kind of cull through all that, take a look at what the business rules are. What does the contract need to say about what the designer has to do, when the designer has to do it? What is the designer going to be paid? What's the client's expectation? Are they going to have what's the decision-making process going to look like? Do they just sit back and wait for the designer to kind of present something and then install it for them? Or is it going to be more, cooperative or collaborative, I guess? And every designer is different. Believe me. I mean, I have clients who are, first-time designers. This is a second career choice for them. They're focusing on they're starting on small residential spaces. Okay. And so that's one type of contract. It really is. I have other clients who do, multi-unit mixed use commercial residential buildings where it's an entirely different role. Right. And so not every contract is going to fit every role. Okay,
and just David, just for clarity, when you end up with these Franken clauses, right? The issue for the designer is you can't enforce what your original intention was. So if your goal was, I'm going to get paid whenever I have a client sign off on an item and I've ordered it, now you're in a situation where there's so many scenarios where that's not necessarily the case, that now you're not protected and now you have no ability to enforce what your original intention was.
Yeah, exactly. That's the thing. Ambiguity equals unenforceability, right? So if it's open to more than one interpretation, then you have that sort of fight between which interpretation is controlling. And what that means is it's just costly and time consuming, right? Mm-hmm. And you could be right. And your interpretation could be entirely what the parties intended, but it's expensive to be right. So let's try and avoid those kinds of ambiguities.
The contract is doing you more harm than good. Yes.
Yeah. And believe me, I've seen scenarios when that happens. So here's just a couple other things to kind of just think of in terms of establishing scope, right? When you are looking at your contract and you're looking at things that are going to be affecting the scope of the work in the contract, clear lists of tasks, deliverables, and due dates, right? And I know not everybody has a due date, and I know that design is fluid, but most of my clients, certainly my larger clients and more successful clients, have things on a timeline. So there's a constant flow, there's a constant movement, and there's, at least calendar expectations so that you circle back with the client and something, this last 18 months or whatever has thrown timelines out the window. But at least you have something to hang your hat on.
And can those due dates work both ways? I obviously there are certain things that the client may want the designer to do by a certain date, but often a designer needs approvals or X things within a certain timeline to keep the project moving and not to be hung up with a particular project. Does that come up in contracts as well?
Yeah, it does. And so if you look at sort of point 3 there, that's at modifications and approvals, right? And that really, in setting up the contract, you have to look at how are approvals going to be processed during the relationship, right? What do I need to get the client's consent to do, right? And does that have to happen within a certain amount of time? What happens if it doesn't happen, right? What's my recourse? So all of those things should be thought of in advance, right? And to some extent that dovetails with the purchasing of things, because some designers, the design is very front loaded, and then once that's completed, then they just simply move to the purchasing phase, and it's really just a matter of a lot of buying and tracking orders. Other clients or other designers are more it's more involved. There is design and purchasing throughout the course of the relationship. So that, you might move through a project, you might move through a house, for example, and as one section is being done, that's sort of leading to what's being done in the next section. So it's more, it's more continuous. You don't really have the separation between the design and the purchasing, right? So just having some mechanism for approvals, and there's some, really customary ways that are that to do it. You can approach it as, pre-approved unless the client rejects it within a certain amount of time. So that's very pro designer. Or you could have it as, client must consent within a certain amount of time, in which case, if they don't, the de facto is, if you don't hear from them, it's okay, they didn't consent to it, nothing happens. So, and then the corollary to that, of course, is what's the designer's obligation after that? Do they get to, do they wait and see? Do they wait for a certain amount of time? Do they eventually walk away from the project, right? All of these things could be, decisions that occur as a, result of the acceptance mechanism.
Yeah. And I know we're going to talk about payments, but that's related as well, right? Which is
absolutely.
Things aren't going to get ordered, or they're really not final until they've been paid for. Yep.
Right. So on that point, moving right along, let's jump into getting paid, right? This is another area that a lot of my clients this is where they run into trouble with their customers, right? More often than not, my designer clients who run into trouble have basically become a creditor for the client. And this, working backwards, this comes to not clear purchasing language. Generally speaking, when you're performing services, there's a couple of different ways to make sure that you don't lose that time, right? Some designers work basically on an hourly basis. Everything they do is simply hourly. It's very easy to manage and track. But eventually, right, your business runs up against, just the limits of the billable hour, right? And there's only so many hours in the day. You can only serve so many clients. You can only grow that so far. Another, form, I guess, of billing is sort of the value billing, right? And it could be a hybrid. There could be an hourly fee in there, but there could also be a performance-based fee, whether it's a percentage of the budget, or whether it's a percentage of the purchasing, or some other revenue stream based on purchasing. Sometimes it's just a lump sum. Sometimes it's, I have clients who say it's $500,000 all in, all the furniture, all my services, blah, 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 will be done in 24 months, right? And then it's on the designer to make a profit on that, right? It's on her. If she goes over that, if she doesn't make any money, well, she's only got herself to blame. So I've seen them all. The important thing really is to make sure it's clear what I advocate my designers do is have some sort of a deposit or some kind of a retainer based payment structure so that you always have money on hand to cover the costs of your services. And I would distinguish that from the deposit for purchase of goods, right? Because that, when you take that deposit, that's clearly to buy something for the client. That's, so in those circumstances, you either, if you have the funds, you buy the item, right? You should not be putting yourself in a situation where you're buying the item and then chasing the client for the funds. Okay. And it happens. But just, in terms of business thinking,
and you're advocating for taking money up front for the work, the time, not just for purchasing products.
Exactly. Taking money up front for the time. And it's project dependent. So if you're doing a bathroom, right, and your whole budget's $25,000, maybe you don't take a $25,000 retainer, right? Maybe you take a $2,500 retainer or something like that. I advocate this because a lot of times designers just don't think about it. And you can have a retainer and just put it aside and say, this is, this will be billed against the last invoice, right?
Okay.
So you never find yourself in a situation where you're chasing them for money. You always kind of have that cushion. And that retainer depends. Other clients, they do by a billable hour. They say, okay, you need to buy 20 hours in advance. Here's the rate when you do that. We'll build through. Once we hit the end of those 20 hours, I'm done working until you prepay the next chunk. It really depends on what works best for the designer and how they feel comfortable doing it.
But either way, that gives you some protection. It's a bit like, right, first and last month's rent, right? You're covered for that scenario.
Yes. Really, I mean, if you're in a services business and you're selling your time, the only way to protect yourself is to have some sort of a retainer on hold to cover that work, right?
Makes sense. Yep.
So that's always pretty important to me. And then it should be clear. It should be very clear to the client exactly what they're paying and what they're paying for. If it's, for example, if it's a $10,000 design fee, it should say that it's one time, non-refundable. You will have X, when you pay me. So I don't want to overdo it. The procurement fee is something that I see a lot of designers struggle with. And there's two pieces to this. I don't want to talk about purchasing where the designer is being compensated based on some sort of markup of the goods. There's this whole other category of services, which I find many of my clients struggle with just in managing the purchasing process, right? Tracking P-orders, talking to the warehouse, talking to the shipper, talking to the insurance company because the warehouse caught on fire. And yes, it happens. And that is the absolute worst time to find out you don't have insurance, okay? Because that has happened to my client as well. But just like for a designer who is the principal of the business, is doing all of these things, it can add up to a lot of time, right? And if you have a client who's particularly fussy or picky or is really making you kind of redo some of this stuff, it's good to have something in the contract that will allow you to bill for that time, right? So, having it stated that these types of services, whether you want to call them administrative services, whether you call them project management services, whether you want to call them purchasing or procurement services, having sort of this category, this catch-all of hourly work that you're doing that you get to be paid for, right?
And when I talk to designers, that comes up a lot. It's obviously a huge time suck. I know when folks have like a design assistant, often, right, they'll have a different rate perhaps that they bill for that design assistant to manage those types of processes. So there's a number of different ways to approach that.
Yeah, absolutely. And even if you're a solo designer or you're not quite there where you have a design assistant, you can have two rates. You can have your professional design fee and then you can have your administrative fee, right? And so, I mean, there's no reason to leave money on the table. I'll talk for a second about, passing on trade discounts. Every designer does it differently. There's a lot of situations, here in Chicago, for example, I know designers who source 100% of their stuff through the mart, right? Because that's just where everybody is. They've got relationships with the showrooms. They've got relationships, it's all wholesale. Other clients buy everything on eBay or Etsy, or so they source it in a totally different way. And so, the problem is that the homeowner is now very aware of sort of this concept that, designers may get discounts that they don't, right? And so my advice to designers is I don't care how you do it, just be clear about it, right? So, if you're going to pass through a discount, just be clear about how it's calculated. That's all you have to do, so that the client doesn't ever feel that you kind of saying one thing and doing something else. That's what causes problems.
It should be explicit, even if you have a client that may not be familiar with it. You recommend educating them on how it works and how your process works, and potentially even positioning it as a benefit for them.
Yeah, and I've seen it addressed in a lot of different ways. Some designers say, I will pass along whatever discount I get, which varies. It varies by the vendor. It varies by the length of my relationship with that vendor. It varies by the size of the order, right? And so until I get that, I don't know. And then I have others who just say, it's a straight fixed fee. It is. It's this much off the top, whatever it is, 25, 30%. The other side of that coin is I have clients who source things in a unique way. And I don't know how to say it any better than that, other than they have very small vendors, very small sources. These are not products that you're going to find in a big box retailer. You're not even going to find a knockoff of this product in a big box retailer. So for these designers, their source is highly protected. It's highly valuable. And there's another way to approach providing those types of goods, which are not, they're not sourced wholesale or generally from the market. And in terms of how you price that, not so much price it, but how you sell it to the client, you need to make it clear in your contract, that the price that it's being sold to the client is the price, right? It's the client can take it or leave it, right? It's not being sold with a markup or something like that. It's not like, well, I bought it here and then I marked it up X%. Now I'm selling it to you. It's, here is the product. This is the price. If you don't want it, great. Don't buy it, right? But if you buy it, this is the price.
This is the price.
You do run into some issues around product warranty, product liability, especially if it's something that's, going to have a long lifetime. Let's say it's a large sofa, right? Or a large table, and maybe there's wear and tear, or, maybe there's some damage to the product. The buyer is going to come back to you and say, okay, listen, you know what, I need, this thing fell apart on me. I need some warranty work done. Right. And so it could create an issue with the designer saying, okay, well, I'm not going to tell you who manufactured it, and I'm not going to tell you where the fabric came from. I'm going to take care of it myself. Right. So it can create some different types of issues.
Makes sense.
Right. Okay. So that's kind of what I want to say about getting paid. It should be explicit, right? It should be clear. I like a combination of, retainer, hourly rate, things of that nature. And again, every contract is different. Just make sure your contract follows your business rules. That
it's clear. So there's no real legal obligation for designers to disclose their trade discount, but you recommend that everybody, I guess, be transparent about whatever their pricing process is, or what the client is going to pay.
Yeah, just be clear about what the client's going to pay. There's no legal obligation to disclose your trade discount, okay, as long as there's nothing in your contract that would make that misleading, right? So, it's just, it's a matter of don't say one thing and do something else.
Got it.
So let's kind of dive into purchasing rules. This is again, another area where I see designers are kind of confused about how to approach it. Homeowners are very often confused. In the commercial sector, you rarely get any confusion. Everybody sort of gets the process. It's really in sort of residential area, residential design where I see the most issue. I call it, furniture, fixtures, and equipment here. It could be, products, it could be materials, it could be decor, decorative items, whatever you want to use it. Just make sure, the terminology is kind of always the same. Mm-hmm. There's really kind of three roles the designer can take. Right. So the designer could first just act as an advisor and say, okay, I've picked, this chair in this finish from this manufacturer. Here, here's the tear sheet. order it, right? So on and so forth, for whatever it is. Sort of a more elevated approach would be, an agent who also maybe has a management role and is maybe handling the contracting process and maybe negotiating the contract to say, okay, here's this built in, I need this mill worker to do the work, I need this painter to do the paint. Here are the, I'll manage the sort of the bid contract process for that, right? It puts the designer kind of in a tough place because the vendor may look to the designer for payment, even though in the designer's mind, the vendor should only be looking to the homeowner for payment, right? The homeowner is looking to not just the vendor for performance, but possibly the designer as well. If there's poor performance, or, I had a situation with a home here in the Chicago suburbs, and, $50,000 worth of custom ordered wallpaper that was installed so badly, the entire thing had to be redone, right? And this is one of these situations where it was more of a handshake deal than a formal written contract. And, the designer wound up eating half the cost because the client was upset. The client wasn't going to pay another 50 grand for this wallpaper because it was, because the contractor put it up wrong. So
it's a great example. It's a great example. I think it really brings it to life because it's a very realistic scenario for so many folks out there.
Yeah, and I wouldn't say it happens often, but it happens, right? So
even on a smaller scale, right? It happens.
Yeah. So that's out there. And then sort of the third way is really where the designer's acting as the retailer, right? And this is a little bit what I was kind of alluding to a few minutes ago, when the designer is just invoicing the client. The designer says, listen, I'm your source. So I'm providing the product, I'm providing any warranty coverage, I'm providing any, repair, returns, whatever. I am the source of that. It gives the designer a lot more control over maybe cost structure and certainly, sourcing products and services. But it also increases risk a little bit to the extent that the designer now has to also kind of, step up and make sure that there's, take some additional responsibility for the goods themselves, right? Which you don't have to do if you're more just acting in an advisory capacity.
And so, what do you see as, what's the most common scenario? What do you see in your contracts most often? Does it vary by the sort of size or stage or, type of work a designer does? And, why would a designer choose one of these over another?
Well, I would say the majority of my clients act more in the capacity of an agent, meaning they will source the goods and then, provide it to the client, basically invoice it to the client, or, propose it to the client, really is a better way to put it. Propose it to the client. If the client says yes, they then invoice the client pays the invoice, they buy the goods. That way it's sort of, they're acting really more as an agent and not as the seller itself. And it still allows them to kind of put their, their markup or their purchasing fee or whatever it is into that product. And that's what I see most of my clients do. I'd say maybe 5 to 10% of my clients don't do any purchasing at all. Like they're just happy to do design. Some of them just do staging. So, but that's, I'd say, the exception of the rule. Almost all of my clients have some role in the purchasing, active role in procuring the goods, as opposed to just specifying them.
Got it. And for that wallpaper example you gave, does that apply, or is it just another term in the contract when you're, getting a subcontractor to do labor and who's liable in that scenario?
So the way I would approach it in a contract would be make it very clear that any tradespeople, any vendors are hired directly by the client. So the client is to pay them directly, but also, if there's any liability on their work, that the client is to look to them directly. So rather than bringing the designer into that discussion, the designer is going to be part of the discussion anyway, but the designer doesn't have to worry about, oh my gosh, am I going to be held liable for what these guys did, right?
How do you deal with, I guess, so let's say this example, the designer has recommended this wallpaper installer, the contract, the client contracts with them, this happens. Contractually, the designer's not liable. But obviously the client doesn't feel good about this because the designer recommended this wallpaper installer. What happens in scenarios like that?
Typically, the designer will step up and make it right with the client.
Okay.
That's what I've seen. It's a business decision. You have to decide what's more important to you, right? Is it more important for me to maintain this particular client relationship and potentially my business reputation? And it's a tough call to make, or how badly did the vendor really screw up here, and do I have a cause of action, right? I mean, do I go after this vendor for what is happening here? So it's nuanced. I'd say everybody sort of meets somewhere in the middle, but generally speaking, the designer has their own reputation to consider, and will often kind of step up and make it right. And I think designers need to think long and hard about the vendors that they recommend, right? You really don't want to get egg on your face by recommending the wrong the wrong contractor, right? So, and there's, tons of great people out there. I see them on the forums. I know that resources like House, provides access to vetted contractors, right? So, I think it's sort of a do your due diligence kind of thing.
Thanks for that clarity, because I know these things come up, and I know a lot of designers sort of build these kinds of issues into their margins a bit.
Yes.
Right?
And you can carry insurance. You can contract. If some of my clients actually are fairly entrepreneurial and have set up sort of referral relationships where they will. They'll say, listen, if I send you a client, you'll give me 5% of the invoice, right? So. And in that case, there's, an even greater incentive to maintain that level of quality.
Good point.
All right, moving right along, termination rights. So termination rights are very important. This is all about your right to walk away from the contract. And generally speaking, unless a contract provides otherwise, it's terminable at will by the parties. So in other words, you can terminate a contract at any time for any reason, for the most part, which is why most contracts have some sort of term and termination language, meaning the term will say this is how long it needs to last, 30 days, 60 days, 1 year, what have you. And then the termination rights will say that, if what the specific mechanics are for terminating the agreement. There's a couple of different types of termination rights. I mean, I don't want to go too far into the weeds, but, we talked earlier about how you can, a contract is basically a legally enforceable promise, right? So when those promises aren't performed, what are your rights? And when we're talking about the design relationship, it's a more complex relationship, because not only do you have the professional services on the design side, but then you also have the procurement side, and you have sort of the ongoing obligations, and then you often have things might change over time. Sometimes design direction changes, and sometimes the motivations of the parties change, and the relationship changes. So what you want to do is you want to think about, in terms of your business, what's your exit strategy, right? What do you need to be able to do to get out of this? And what do you want to hold your client to? So, things like, if a client stops paying you, do you have the right to terminate the contract? Do you have the right to stop performing? And, the answer is yes, right? No, we don't have indentured servitude. If a client isn't paying you for your services, you don't have to keep performing those services. You certainly have a right to stop performing those services and wait until the client is willing to pay you what they owe you. And yes, that might mean stopping mid-project when, when you've got vendors on hold and you've got products coming in, and you know what, it's, you have to decide what the, how much pain are you willing to endure? At what point do you pull that lever and say, listen, I'm stepping back?
So does that example fall under like an intermediate term for the designer, where it might give
I would say, a failure to pay is not necessarily a breach of contract unless it's necessarily defined as that. So in different types of contracts, the way the value is exchanged, there may be a greater risk if there's a failure to pay, right? So if it's let's say something where 100% of the value is received immediately, like let's say a CD, a song, right, or a movie or a television show, right? So you've consumed this, but now you decide you don't want to pay, right? So at that point, you've received 100% of the value of that, and the other side received no value. Versus something that's more maybe intermediate, or services where you could say, okay, I've performed these services, but I can stop performing services. I don't have to perform any more services. It's less of a breach of contract, let's say, than sort of a pause in a condition, right? So you're not necessarily terminating the agreement, but maybe you're pressing pause. It really sort of depends on how you want to communicate it to the client.
Got it. So what would be an example of a breach of contract? A breach
of contract would be violating like a specific obligation. Like let's say, you've agreed to hire the designer, and the contract provides that the designer will do some of this additional work, okay? And instead of allowing the designer to do the additional work, you go around the designer, maybe you hire somebody else to do that work. So you kind of cut them out, right? Or it's hard to think of an exact situation off the top of my head, but usually if there's sort of like a mutual obligation, and one party's obligation is really dependent on the other party's obligation, a failure to perform in that case might be an essential failure of the agreement, right?
And so what's the difference between a breach and a default?
Really, it depends on the definition. Okay. Both of those are defined terms. I see them kind of thrown around. And this kind of harkens back to sort of the beginning of the discussion about, just being precise in drafting language and using defined terms properly, right? And so if you're going to define what a breach is, and then refer to it as that. Or if it's a default, use that term, make it clear that it's a default. In general, I mean, the terms, have a fairly common understanding. A breach is sounds like a failure of an obligation, right? Or a default, again, sounds like a fault, a failure to do something. Yeah. The problem is, what are the consequences of that failure, right? What is the remedy that results from that failure? And if it's not in the contract, it may not exist, right? So that's why we talk about termination rights, and making sure that from the designer standpoint, you're drafting in the terms that give you control of the contract. I want to make sure the client can't walk away from me, so I require 30 days advance written notice to terminate. Okay. Yeah. The client can terminate, but at least I've got 30 days notice to wind down my affairs, send out a final invoice, do whatever I have to do, versus can terminate at any time, in which case you get a call. Yeah, I'm done with you. Goodbye. Right. So it's things like that. It's just putting control back in the hands of the designer. You can get more complex with termination rights, especially if you're doing on a flat fee or prepaid fee. Let's say the designer's the client's prepaid. Client's giving you $50,000 in advance. You start working with the client. 5 days in, you're like, no way, I'm not working with this person anymore. This relationship's not going to get, it's simply not going to work. The termination provisions should say what happens to those prepaid fees. Is there a portion of it that's non-refundable? There could be, or is there a portion that's refundable? And you contrast that with, well, what if I'm 5 days in and this or 10 days in, whatever it is, and now this client is causing me problems. They're putting roadblocks in front of me. They're calling my vendors. They're rescheduling things. They're doing things that are preventing me from doing my job, right? In which case, if the client is in breach, then maybe all of that prepaid amount is non-refundable, right? So there's different ways to think about that kind of keeps each side's feet to the fire.
Got it. And of course, the companion webinar to this would be how to have the conversations, right? Because we came with the wallpaper example. There's always the business decision and the relationship decision, right? You may have the right and the ability to do all of these things, but what you actually do and how you handle it is often more complicated.
Yeah, absolutely. And I do frame my advice to my clients that way. Right. There's what the contract says and what your legal rights are. And then, there's also the business decisions to be made, and you have to look at everything. And I have had clients who said, you know what, I just got to walk. I don't care what this client says about me. I don't care, what happens. I don't care how much money I'm walking away from, and others who are like, just desperate to make that relationship work. So it's 100% a business decision. And you definitely need to have that webinar with people more qualified than I am, to frame that discussion.
Perfect.
So
that helps a lot. I think that helps a lot because folks want to know what do I put in my contract, but then how do I need to be thinking about it, right? And when these scenarios arrive, what do I need to be prepared to do and to say?
Absolutely. All right. So we talked a little bit more about non-essential terms versus, essential terms. And this goes back to this idea of default and breach. And, like I said before, sort of the more serious obligations, right? So the obligations that are sort of understood to be inherent in the contract, these are going to be the types of terms that are, more material. And the breach of these types of obligations is going to cause damages, right? Breaching some obligations doesn't necessarily cause damages, but, obviously when it's a more material term, like, when I contracted for you to, install the kitchen sink, of course, I assumed that the water was going to be running through it, right? Not that it was just going to be sitting there, in the mount. Right. So, I mean, there's this whole idea about, implied conditions and things like that. And one of the things that I see is because design is a creative endeavor, it's a little bit more esoteric. It doesn't always lend itself to really objective standards, right? So that can be something, that designers should think about in terms of how they're drafting their contracts. How concrete do they need to be? How specific do they want to be? And, how conceptual do they want to be? So I think just kind of balancing those things comes down to, making sure that you've got the right kind of terminology in your contract, and, you're thinking about things that matter. To kind of maybe shed a little bit of light on this, I have a client out on the West Coast who asked me literally to put in a clause about wood beetles. And she's like, I just want to make sure I'm not liable for wood beetles, right? And I said, okay, I could do that, but I'm like, is that such a big part of what you do that you have to worry about this? Number one. And number two is, are you telling your clients that they need to be concerned about wood beetles, right? I mean, why would anybody be that concerned? Because a general disclaimer, right? Or it's, if you're not the manufacturer of something, right? I mean, why would you be responsible? So it's just, try not to lose the forest for the trees there, right?
Good point.
Okay, so lastly, here we talk a little bit about default, breach. Again, these are kind of the same things. There's different terms. different terminology. One of the things that I think a lot of people don't always understand is you can say the same thing with different words. So a lot of times clients will, I'll send them a contract, I'll send them a markup or whatever, and then they'll say, well, Betty Jones over here, her contract says this. And I'll be like, okay, well, we both get from A to B, we just get there in, different routes. So just, kind of understanding that there is different, terminology and different style. But at the end of the day, it's really what it says that matters. Lastly, right, mind the details. Again, it's important not to lose the forest for the trees. You don't want a clause for this and a clause for that and a point about that. And, again, I'm not taking, deliveries on Tuesday between 9 a.m. and 10 p.m. Because what happens is when you're very, very, very specific, the specific sort of rules out the general. So you definitely want to have, some general provisions around the nature of the relationship. One of the things that I see happens in contracts is, so thinking about the scope of work is often the most variable part of a contract, right? These tasks are going to vary. Their timelines are going to vary. What you're doing for a particular client is going to vary. Sometimes I see that in the body of a contract, so that every time there's a new client and every time that section gets revised, it has an effect on the rest of the contract, right? So what it does is it causes those ambiguities, or it causes some things to cancel each other out. Versus approach that I see, which is a more standard approach, is to kind of have the scope of work separate and basically say, sort of self-contained, so that the main body of the agreement really doesn't change very much, right? It's sort of stays standardized, and it's, the relationship, the rules of the relationship, or the rules of the road, if you want to call them that, are kind of all there. And it's really just the variable items for a particular project that are changing.
And to that point, I see one of the quotes here says, review your contracts at least once a year. Does that mean, hey, designers should just read through them and make sure everything still matters, or they need to go to an attorney once a year to have it reviewed? What's the recommendation there?
So I think it depends on your circumstances. Some of my clients do come to me every year and they say, okay, Dave, let's take a look at the contract. This is what happened in my, business last year. Where is this addressed in my contract now? Is this something that we need to think about going forward? One of the biggest things that I saw, recently was the push to reevaluate force majeure clauses, because every state handles force majeure differently. Some states like New York, it's, if it's not written in the force majeure clause, it is not a force majeure. Other states like Illinois have a more expansive approach to force majeure clauses. So
can you define that for the folks watching?
Sure. So force majeure is a legal term of art. It basically means something has happened, an event has happened that is preventing one party from fulfilling their obligations under the contract. And because of that event, that party might be excused from all performance under the contract. Okay. In other words, this event is just so substantial that I can never do my job. I can never fulfill this, like in the case of maybe natural disaster, right? Like I'm building an addition to this house, but then hurricane comes through and there's no house anymore. Okay, so I can't possibly build an addition to a house that doesn't exist, right? Versus something like, let's say there's a work from home mandate, or there's a mask mandate, or there is, a stay-at-home order, and you can't go into the showroom, you can't go into, a client's house, you cannot meet with a vendor, right? Does that mean that, all bets are off, you never have to finish your contract? Or does that mean we kind of like pause things until everything changes, right? And the truth of the matter is, most of the time these things can be worked out. Really, what force majeure looks at is sort of this idea of impossibility of performance. And, is there this event that has basically made it impossible for me to perform under any conditions, even if it goes away, right? Or it's never going to go away. So that kind of thing.
Did you see designers adding new terms during COVID to their contracts?
I did. I saw a number of clients adding force majeure especially, those clients of mine who also have a showroom or who have, a retail presence where they have both other designers as well as tradespeople and clients coming in. I saw a lot of that in those areas, certainly New York, California, where there were, I think, both not necessarily greater restrictions, but greater adherence to the restrictions, and here in Chicago as well. So I saw some changes. I see other things too. Different things can happen year over year. If you just had your contract torn down by a lawyer and everything was zipped up tight and T's crossed, I's dotted, great. I'm sure you don't need to take a look at it immediately 12 months later. But it is something that you should be thinking about. You should be reading at least once a year. Read through it, right? Is it grammatically correct? Do I have things in here that I don't do anymore? Do I have things in here that I'm doing that I'm not seeing in here? So how can I, have there been changes in the law that I maybe need to think about? So, it's always a recommendation. It doesn't mean that the contract has to be gone over with a fine-tooth comb and it's going to be like a 5-6 hour rewrite. But it's definitely just good housekeeping practices.
Super. Thanks for the clarity.
My pleasure. So yeah, I mean that's kind of I think what I have to say on contracts.
So we do have some questions from our
Absolutely.
audience here. So let's say, I think we've got a few minutes to get to some of these. Julia wants to know, what's the most overlooked item in a designer's contract?
The most overlooked, probably something to do with contractors, working with third-party contractors. I rarely see that in the contracts that I've been asked to review. It's something I find I'm often adding in. That and another one might be some form of a no-shop clause or an exclusivity clause that makes it clear the client, or I should say the designer, is the sole source of products or furnishings or decorative items that are suggested by the design or suggested by the designer. So that's something that's not always in there. And sometimes it also kind of depends on the relationship to the size of the outfit, but I'm seeing sometimes no poach clauses, non-solicitation clauses.
Got it. Super helpful. Let's see. Martha wants to know, so we talked about, adding those termination clauses into contracts. How do you protect the designer from losing, any payment due when that happens on the part of the client? I know we talked about building it in, but any other thoughts on how to protect the designer and make sure they get paid?
Right. So the best approach, right, in a perfect world, is that you get paid in advance. So you get some kind of a retainer or deposit before you do the work, so that you are always billing against that and you're never waiting to get paid. For purchasing any sorts of goods or things of that nature, or contracting out services of third parties, making sure you get a deposit or you get 100% payment of that in advance so that you're not out of pocket on your own. And then, there will always be these situations where you may be chasing a client for money. And the best thing I can tell you to do is make sure that your contract allows you to recover costs and attorney's fees, collection costs, and that it is drafted broadly enough to include non-litigation tactics. So in other words, maybe send something out to collections. Maybe you just, you hire somebody to, just can make some phone calls, or, less formal, so that you can at least recover that cost. Under the sort of American system, each party pays their own way. So unless a contract specifically provides that you can recover costs and attorney's fees, a court won't give that to you. So having that, again, it's not necessarily going to prevent you from having to collect from a client, but it does give you sort of an extra arrow in your quiver in terms of, if you had to go after that client, at least you would have some additional remedies there that are available to you.
Super. And the last question we have is, I think you'd probably say, hey, designers, you can't afford not to have your client, your contracts reviewed by an attorney. But of course, they're wondering, like, is this an expensive process? Obviously, hourly rates vary, but, how many hours do you think an attorney would typically spend, reviewing and identifying these issues with a designer's contract? And is it affordable?
Yeah, it is. Lawyer rates vary depending on, geography, experience. I've been practicing 24 years. I can tell you that my rates are definitely below market for Chicago, New York, and LA, which I have clients in all three of those markets. But there's certainly, I've been practicing 24 years, so my rate's a little higher than a young associate, right? The thing to keep in mind is that when you're paying a higher rate, you should be getting a little bit more experience, a little bit more efficiency. So even though it might cost more to have me review a contract, it may not take me as long, and I may be able to sort of cut more finely in terms of, what needs to be done, right? So, I'd say try not to look at it strictly from an hourly rate perspective. And then just, to answer the general question, I'd say most contract review projects for an interior design contract are in the 2 to 3 hour range. Okay. And that's time to review what the contract currently says, figure out how it can be made better, discuss those issues with the client, make those changes, turn around the final version. So all of that takes about 2 to 3 hours. Can it take less? Yeah, absolutely. I mean, you could send me your contract and say, hey, you know what? This is perfect. Don't change a thing. Here it is, right back at you. But I'd say somewhere in that range.
Super. Great. Well, gosh, David, we were so lucky and so appreciate the time that you gave us here to cover these issues. I know this is going to be a huge help to so many designers out there. So thank you. And thanks to everybody for joining us today. And we'll see you back for more of these educational sessions soon. Thank you.